International Covenant on Civil and Political Rights, General Comment Number 18, Non-Discrimination. 1. Non-discrimination, together with equality before the law and equal protection of the law without any discrimination, constitute a basic and general principle relating to the protection of human rights. Thus, Article 2, Paragraph 1 of the International Covenant on Civil and Political Rights obligates each state party to respect and ensure to all persons within its territory and subject to its jurisdiction the rights recognized in the covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Article 26 not only entitles all persons to equality before the law as well as equal protection of the law, but also prohibits any discrimination under the law and guarantees to all persons equal and effective protection against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. 2. Indeed, the principle of non-discrimination is so basic that Article 3 obligates each state party to ensure the equal right of men and women to the enjoyment of the rights set forth in the covenant. While Article 4, Paragraph 1 allows states parties to take measures derogating from certain obligations under the covenant in time of public emergency, the same article requires, inter alia, that those measures should not involve discrimination solely on the ground of race, color, sex, language, religion or social origin. Furthermore, Article 20, Paragraph 2, obligates states parties to prohibit, by law, any advocacy of national, racial or religious hatred which constitutes incitement to discrimination. 3. Because of their basic and general character. The principle of non-discrimination as well as that of equality before the law and equal protection of the law are sometimes expressly referred to in articles relating to particular categories of human rights. Article 14, Paragraph 1 provides that all persons shall be equal before the courts and tribunals, and Paragraph 3 of the same article provides that, in the determination of any criminal charge against him, everyone shall be entitled, in full equality, to the minimum guarantees enumerated in subparagraphs A to G of Paragraph 3. Similarly, Article 25 provides for the equal participation in public life of all citizens, without any of the distinctions mentioned in Article 2. 4. It is for the states parties to determine appropriate measures to implement the relevant provisions. However, the committee is to be informed about the nature of such measures and their conformity with the principles of non-discrimination and equality before the law and equal protection of the law. 5. The committee wishes to draw the attention of states parties to the fact that the covenant sometimes expressly requires them to take measures to guarantee the equality of rights of the persons concerned. For example, Article 23, Paragraph 4 stipulates that states parties shall take appropriate steps to ensure equality of rights as well as responsibilities of spouses as to marriage, during marriage and at its dissolution. Such steps may take the form of legislative, administrative or other measures. But it is a positive duty of states parties to make certain that spouses have equal rights as required by the covenant. In relation to children, Article 24 provides that all children, without any discrimination as to race, color, sex, language, religion, national or social origin, property or birth, have the right to such measures of protection as are required by their status as minors, on the part of their family, society, and the state. 6. The committee notes that the covenant neither defines the term discrimination nor indicates what constitutes discrimination. However, Article 1 of the International Convention on the Elimination of All Forms of Racial Discrimination provides that the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise, on an equal footing, of human rights and fundamental freedoms in the political, economic, social, cultural or any other field of public life. Similarly, Article 1 of the Convention on the Elimination of All Forms of Discrimination against Women provides that discrimination against women shall mean any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil or any other field. 7. While these conventions deal only with cases of discrimination on specific grounds, the committee believes that the term discrimination as used in the covenant should be understood to imply any distinction, exclusion, restriction or preference which is based on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status, and which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise by all persons, on an equal footing, of all rights and freedoms. 8. The enjoyment of rights and freedoms on an equal footing, however, does not mean identical treatment in every instance. In this connection, the provisions of the covenant are explicit. For example, Article 6, Paragraph 5 prohibits the death sentence from being imposed on persons below 18 years of age. The same paragraph prohibits that sentence from being carried out on pregnant women. Similarly, Article 10, Paragraph 3, requires the segregation of juvenile offenders from adults. Furthermore, Article 25 guarantees certain political rights, differentiating on grounds of citizenship. 9. Reports of many states' parties contain information regarding legislative as well as administrative measures and court decisions which relate to protection against discrimination in law, but they very often lack information which would reveal discrimination in fact. When reporting on Articles 2, 1, 3, and 26 of the Covenant, states parties usually cite provisions of their constitution or equal opportunity laws with respect to equality of persons. While such information is of course useful, the committee wishes to know if there remain any problems of discrimination in fact, which may be practiced either by public authorities, by the community, or by private persons or bodies. The committee wishes to be informed about legal provisions and administrative measures directed at diminishing or eliminating such discrimination. 10. The committee also wishes to point out that the principle of equality sometimes requires states parties to take affirmative action in order to diminish or eliminate conditions which cause or help to perpetuate discrimination prohibited by the Covenant. For example, in a state where the general conditions of a certain part of the population prevent or impair their enjoyment of human rights, the state should take specific action to correct those conditions. Such action may involve granting for a time to the part of the population concerned certain preferential treatment in specific matters as compared with the rest of the population. However, as long as such action is needed to correct discrimination, in fact, it is a case of legitimate differentiation under the Covenant. 11. Both Article 2, Paragraph 1, and Article 26 enumerate grounds of discrimination such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. The committee has observed that in a number of constitutions and laws not all the grounds on which discrimination is prohibited, as cited in Article 2, Paragraph 1, are enumerated. The committee would therefore like to receive information from states parties as to the significance of such omissions. 12. While Article 2 limits the scope of the rights to be protected against discrimination to those provided for in the Covenant, Article 26 does not specify such limitations. That is to say, Article 26 provides that all persons are equal before the law and are entitled to equal protection of the law without discrimination, and that the law shall guarantee to all persons equal and effective protection against discrimination on any of the enumerated grounds. In the view of the committee, Article 26 does not merely duplicate the guarantee already provided for in Article 2, but provides in itself an autonomous right. It prohibits discrimination in law or in fact in any field regulated and protected by public authorities. Article 26 is therefore concerned with the obligations imposed on states parties in regard to their legislation and the application thereof. Thus, when legislation is adopted by a state party, it must comply with the requirement of Article 26 that its content should not be discriminatory. In other words, the application of the principle of non-discrimination contained in Article 26 is not limited to those rights which are provided for in the Covenant. 13. Finally, the committee observes that not every differentiation of treatment will constitute discrimination. If the criteria for such differentiation are reasonable and objective, and if the aim is to achieve a purpose which is legitimate under the Covenant,